Good afternoon, everyone. Allison Skovberg here. We are happy to be back with you today. Today, we are talking about the four things that you need to know about protecting your child with special needs. We are happy to be back with attorney Michele Goldberg, and she's got a lot of insight for us today, lots of experience, and this is going to be a real treat. I always like to start off with a little housekeeping items. First of all, if you're here for the very first time, welcome. We're glad you're here. If you've been attending our webinars for years, we appreciate that so much. Consolidated Planning Group is a holistic special needs financial planning firm, nationally certified as Social Security advisors, members of the Special Needs Planning Academy, chartered special needs consultants. Our whole firm is nuanced in planning for special needs, but we don't do what Michele does. Michele, I say we're the money and she's the paper, the legal documents, the things that matter, really, really matter. You gotta have both. She doesn't do what I do, and I don't do what she does, but we work closely together. So from a perspective of housekeeping, we are in webinar mode today, which means that we can't see you or hear you, but we know you're out there and we're glad you're here today. We invite you to put your questions in the chat box. We'll get to as many questions as we can during our time together. We're going for an hour today, so if you're planning your lunch or planning your schedule, it'll be about an hour. Today's webinar is being recorded. And everyone will get a copy of today's slides as well as a link to the recording, and all of our past recordings live on the Consolidated Planning Group YouTube channel, which you can subscribe to for free. There are over 500 webinars on planning for special needs out there, so you can search the topics for kind of the step that you are on in your journey. We help people put lifetime protection plans in place, future care cost estimates, who's going to care for my child when I'm gone, how do we fund that special needs trust. A lot of people come to us because they need to know how and when to apply for public benefits, and I know Michele's going to talk about those public benefits today, and we help with all of those things. So having said that, Michele, welcome back. Thanks for joining us today. I should also mention that we have several write-in questions. So if you wrote in a question, I have it, and we're going to address those questions. So you don't need to put that in the chat box. If you have a question that comes up today that you didn't already send in, then feel free to put that in the chat box. So having said that, Michele, I'm going to turn everything over to you, and thank you again for being here with us.
And thank you for inviting me. I appreciate it.
I guess you have to go over your disclaimer, huh?
Yes. Yeah. Let me do this. I was looking at it thinking, what? Sorry. Yes, I will answer questions with a general answer. I'll tell you what the law is. But something just happened with my Zoom. I lost you.
Can you see the screen okay?
No, I can't. Hold on. I'm
okay.
Join a new meeting. You will leave this meeting to join. I don't want to do that. Somehow I got lost. Can you see me?
Yes, let me stop my share, and I'll share it again, and then you should be able to see it okay. Can everybody else see the slides okay?
No, something happened with my computer. It logged me off altogether here. I mean, I can hear you, but I don't see you. I don't know if I should click onto this Google Drive again.
Okay, can you see the slides now?
Hold on. I apologize to everyone.
I think we lost her. Okay, she will be back with us in just a moment. Okay, you are muted on our. Okay, there you go.
Something happened with my computer. I apologize. Yes, I will be giving general information. Don't hold it as the gospel as advice for your child, even if I'm addressing your specific question. It's general information. If you have legal issues, if you have a special needs child, I strongly advise you to speak with an attorney that specializes in special needs planning, so that you can get advice that's appropriate for your child and your family. Okay, I am a big proponent, as I know Allison is, we talk about this a lot, why you have to have Medicaid, why it's important. And I have people say to me, we don't need Medicaid, we have medical insurance through work. My parents have a property in Central Texas. We're in Texas here. I don't know where everybody else is has joined us from, but my parents have property in Central Texas. My uncle's a doctor. We're going to have him out there. Everything will be fine. Medicaid, there are different government benefits that you need to plan. I suggest that you plan for if you have a special needs child. Medicaid may be the most important. Medicaid is comprehensive medical coverage. It's free. Some doctors won't accept it because it doesn't pay them very well, but hospitals accept it. And it also pays for medications. There may be some limitations, or you may have a copay, but Medicaid is not only medical insurance. In contrast to Medicare, Medicare is only medical insurance and prescription coverage. And you need a supplement with Medicare. It's not free. You have to pay a premium. Medicaid is totally free. And it's Medicaid is the program, the government benefits program that pays for programs for your child. And it may or may not be a program that you want to enroll your child in, but when they're done with special education and you're looking for programs for them, sheltered workshops, other kinds of programs for them, if the program is Medicaid certified and your child is receiving Medicaid, then the program can bill Medicaid for your child's participation in the program. This is a really important planning factor for you. And Medicaid is the benefit that pays for housing. You may never need it for your child, but we always plan for it. If the residential facility or housing, a group home, a facility, whatever the residential placement is that your child may need, and it's not now while your child's at home with you, we're talking long-term planning, 20, 30, 40 years from now, when you're gone. If your child is on Medicaid and receives Medicaid, then the facility, the group home, whatever it is, can bill Medicaid for his or her place there. So it's an essential planning tool. We always plan to maintain eligibility for Medicaid.
Michelle, I think one of the confusing factors in Texas, I think there's 109 Medicaid programs in Texas. So if you've ever felt confused by Medicaid, that's why. And they have different qualification factors. But one of the things that she's speaking of are Medicaid waivers. And they're really designed to waive off some of the cost of care for caring for an individual to keep them in home and community-based services and out of being institutionalized. They might pay for various therapies, minor home modifications. Some of the waivers pay for housing, some of them don't. But they might pay for attendance services or respite services, summer camps, transition programs. There's so many things. And depending on what waiver that they may qualify for in the future depends on the budget and also depending on their level of need. But so some people, and to Michelle's point, they think Medicaid and they think poor, and that's not always the case. It's often not the case for these Medicaid waivers. And some of these waiver budgets, like for instance, the HCS waiver budget for the highest level of need is like $340,000 a year. So what I say is that's not nothing. That is significant and would significantly defray some of the costs that you will have to shell out for the future care of your loved one. And that is why it's so critically important. So this is so, so important. I'm so glad you had this here.
Yes. So governmental benefits are administered, governmental benefits come from the federal government. Some states add in, the state of Texas doesn't. The states that do, like California, New York, and some others add in, but they also have very high taxes that we don't have here in Texas. So they've got state income tax, city income tax, etc. But the benefits are administered through the Social Security Administration. So you'll hear me and other people that work in this area talk about Social Security. Just as a little background, when we all retire and start drawing Social Security retirement benefits, the amount we get is based on our earnings record, the amount of taxes that we've paid in over the course of our working life. So our FICA, our Social Security, our Medicare taxes. If one of us became, heaven forbid, disabled and we apply for SSDI, Social Security Disability Insurance, once again, the amount that we would receive is based on our earnings record, the amount of taxes we've paid in. What happens to the special needs kids? Those who have a disability that onset in childhood through no fault of their own or their parents, but they have a disability and they won't be able to have an adequate earnings record, even if they work part-time, they won't have much of an earnings record because they won't have paid those taxes into the system to get Social Security benefits. So the government offers something called SSI, Supplemental Security Income. And that is for people that have never paid taxes into the system or their taxes are minimal. And it's a needs-based program. In the year 2025, the maximum anyone could get from the federal government, and Texas is subject to the federal FBR, the federal base rate, is $967. The increase, Allison, correct me if I'm wrong, for 2026 is going to be 2.7%. So there is the cost of, is that correct?
Yeah, it's going to be 994. It's going to go up from 967 to 994 a month.
Okay, well, that's close to $1,000. And it's not, and people go, well, how can you live on that? It's close to $1,000 and it's non-taxable and it won't be your money. It's your child's money. We're talking about when your child's over the age of 18. When your child's under the age of 18, your child may not be eligible for the SSI, Supplemental Security Income, because the government has the right to look at your combined incomes. So you want to make sure that you maintain the eligibility. And what's important here when applying for these benefits is there has to be a disability, and then it's not enough that there's a disability. You have to show through that because of the disability, your child will not be able to support himself, fully support himself through work, or in the Social Security Administration's words, he won't be able to be gainfully employed. 2,000 in combined assets, and it's been 2,000 in the 30 years I've been doing this. I just got a message. My internet connection is unstable. I'm so sorry. I hope nothing shuts down again. I don't know what's going on here. The more than 2,000 in combined assets, that's money sitting in accounts and wherever combined. Or in the year 2025, no more than $967 a month in income. And so you need to look at both the disability and make the case of why your child can't support himself through work to be eligible for SSI and what the finances are. If there is money, then there's ways to handle it. And that's why you need to speak with special needs planners. You may need a special needs trust and you can transfer the money into the trust. I always ask clients, did your parents set up UGMA accounts, the United Gifts to Minors? The child becomes the owner when he's 18, or an UTMA, the child becomes the owner when he's 21. There are types of custodial accounts. 529 plans, people always want to know about 529 plans for educational purposes. They're exempt because they're for educational purposes and because the parent or grandparent is the owner of the account. The child is the beneficiary. So you need to work with someone that works in this area that can explain the differences and the nuances and how to handle that.
Michelle, I wanted to just talk about just like take this just a little bit of a step further. So SSI, means based, income asset based for SSI, and again, it's going to be 994 in 2026. But the other program, Social Security Disability, that's where we pay into it. As a parent, when we work, we pay into this system. But so some people might not get excited about 994 a month. It's not that much. But later down the road, when we have a child who has a disability, whose disability started prior to age 22, they have the ability to be covered under a parent's record. So when a parent turns on their Social Security or Social Security disability, that disabled adult child is going to be eligible for 50% of that parent's full retirement age. And there are such things as family maximums when we have more than one child, etc. but that's where it could go up exponentially. So if dad's, social security is $4,000 a month, that kid will switch over from SSI to the childhood disability benefits, formerly called DAC for 40 years, and now it's called childhood disability benefits. And then they'll start getting $2,000 a month. They'll get to keep Medicaid. They may have to reapply in Texas, but they'll get to keep Medicaid. And after 24 months, they're going to get Medicare. So
Correct.
one person asked the question, Michelle, can I get SSI and SSDI at the same time? The answer is yes, but it's not likely. So it's whichever benefit is the higher amount. So if 50% of dad's record isn't more than SSI, they may get some portion of SSI and some portion of SSDI, but it's not stackable. So I do want to make that clear. It's not stackable. They're going to get the higher benefit. But this is the why behind it, and that's going to continue. That 50% amount is going to continue for your disabled adult child as long as the child remains disabled, as long as the parent remains alive. And once the parent passes away, they're going to move over to survivor benefits, and that benefit amount is going to increase to 75%. So I just want to make that clear because these benefits, Medicaid and Medicare, do stack. You would be considered dual eligible. But moving over from SSI later when the parents retire or become disabled is a much higher monthly amount that they would be getting.
Can I add something before you go on to the next
Sure.
slide? And you explained that so well. I want the audience to be aware that Medicaid, eligibility for Medicaid is linked to SSI. The amount of SSI, and then there's a way around it. That's just the beginning statement. SSI is always capped. So we've both mentioned the numbers of $967 a month for 2025, and it'll increase to $994 for 2026. When your child starts receiving SSDI based on the parent's earnings record, and it can only be on one parent, and it's always been the higher dollar earner, correct, Allison?
It's only on one parent, but the Social Security Administration are order takers. So if mom retires first and it's a lower record, then maybe it's on mom's record, but then dad retires, you have to tell the Social Security Administration to move them over to dad's to get the higher amount.
Yeah, really good point. And you will get a letter from Medicaid saying that because of the increase in monthly income, in other words, they're getting SSDI now based on the parent's earning record, your child is losing the Medicaid, you have to reapply. And they give you a very brief window. Right now it's 30 days. Don't miss it. I have people calling me, well, I got this letter and I was so busy, I didn't do anything. When does your 30 days run? Tomorrow. You're taking off of work and you're going to the Medicaid
Yes,
office. Well, I can't leave work. Well, then your child's going to lose the Medicaid.
right.
And
And
remember,
and so to
Allison,
your point though, Michelle, I
yeah,
think what you were saying is like there are protections under the law because people get nervous that when they switch over to the higher benefit that now they're going to have too much income and they're going to lose Medicaid. So yes, in a perfect world in Texas, you shouldn't have to reapply for Medicaid, but I had exactly two people last year that it went perfectly. Everybody else had to reapply when they switched over. But you are a mandatory Medicaid group. If you were getting SSI and Medicaid first and are losing Medicaid simply because you switched over to the higher childhood disability benefits or survivor benefits, they are a mandatory Medicaid group and they cannot be denied that. So we just want to make that so clear because that's a very, very valid point.
we
Okay,
can do,
are you ready to move on to the next
yes,
slide? Okay, perfect.
the special needs trust. I love my special needs trust. Love my special needs trust. So the government's policy, as I mentioned earlier, is that you can get government benefits if you have the disability, excuse me, and because of the disability, you can't support yourself through work, and you have to be basically indigent. And as both Allison and I mentioned, the government defines indigency as less than 2,000 in combined assets and less than 967 a month for 2025 in income. However, the government says, you know what, you can have a fund of money and to provide all of the quality things for your life. that the benefits don't cover, because the government benefits, SSI, is earmarked for food, clothing, shelter, food, clothing, shelter, food, clothing, shelter, and you get the medical insurance, which is the Medicaid. So you can have a fund of money to provide for extra therapies, for vacations, for eyeglasses, for care management services, for clothing, for cultural events, for tickets to sports games, to shows, whatever you like. Vacations are always a big one, going out to eat. And the trust is the way of having that fund. But the government's policy is you can have this money and still be eligible and still keep your benefits on condition it's structured in this thing called a special needs trust. The trust is a legal document and is governed by the Social Security Administration. It's governed by federal law, so it has to have certain things in it. And there's three kinds of special needs trust. One is a pooled trust. If we have time, we'll get to that later. But what's really important is a first-party trust and a third-party trust. And who determines which trust you're going to use is the Social Security Administration. So let's talk about the third-party trust first. The third-party trust is a trust that is, and I want to back up and say something. When you hear about trust, quite often, I know you're not all here in Houston, but when you hear about trust, you think of those super wealthy people, oil money, they live in certain neighborhoods. No, a trust is a trust is one person or a bank or a corporate trustee, a professional trust company is managing the money on behalf of somebody else. That's what a trust is. So, and then the trust document, what the attorney prepares for you is the instructions of how the money has to be managed, who the beneficiary is, what happens when the beneficiary dies, where the money is distributed to after the beneficiary's death. The beneficiary on a special needs trust is going to be the person with disabilities that needs benefits or is receiving benefits. A third-party trust is funded with someone else's money. So you've got your special needs child. It can be funded with your money, with the parents' money, the grandparents' money. Sometimes there's an aunt and uncle or uncle that want to contribute. The trust, the somebody else, a third party, is putting money in the trust. And to me, a trust is like a business entity in a way. The trust owns the money for the sole benefit of the person with disabilities. The third-party trust is an essential planning tool for your estate plan, because you say, on my death, I designate these investments, I designate the life insurance policy or portion of it, I designate a portion of my estate to fund my child's special needs trust. On his death or her death, then you say who will receive any remaining assets. So it can be the other children, or nieces and nephews, or charities, or a combination of those. I see families want to do all kinds of things. It's an essential part of estate planning. It's essential if you have grandparents or other family members that want to contribute. There's no payback provision to the state of Texas or to whatever state you're in. There's no Medicaid payback provision. The first party trust is the one that has to have a Medicaid payback provision. So what does that mean? That when the beneficiary, who is the person with disabilities, on his or her death, the state that issued Medicaid for the person has to be informed of the death, and excuse me, the state reimbursement office can put a claim on any money left in the trust. And you may be thinking, well, why would I do that? I mean, why would I do that? Well, it's all Social Security regulations. You know, why would I pay back the state of Texas or any state when I could let the money pass on to whoever I want? The first party trust is funded with your person with disabilities, with the disabled person's own money. How would he have money? Oh, proceeds from a lawsuit settlement. We see a lot of trusts like that, and they usually have quite a bit of money in it because there was some sort of lawsuit settlement, a medical malpractice case or an accident, something like that. It's also funded with money from a direct inheritance. I've got cases now. It's a new client, 2 children. Mother died prematurely. She had life insurance policies and left the children with disabilities as the beneficiaries of the policy, didn't create a special needs trust. So we have to go to court and get court permission to create the first party trust and then put it in there and then get approval from Social Security. Once again, it's funded with money that was coming directly to the person with disabilities. So that was a direct inheritance through life insurance proceeds. A lot of people have wills and they don't say, they just say, I want this child to get so much of my estate, 40% of my estate, 50, whatever it is of my estate. But you can't leave money directly to the person who needs the government benefits, because then they have too much money and they're going to disqualify. Some people have those UGMA or UTMA accounts, custodial accounts that I mentioned before. So there's different ways. Oh, and a really essential, and some of the questions that came in before we started were about child support. Child support, Texas has this, I would imagine I don't practice family law anymore, fortunately for me, unless it's involving a special needs child. Texas has a law, and I would think the other states do too, but I don't know. There's something called indefinite child support for an adult child with disabilities. So under Texas law, as long as if the disability onset prior to the age of 18, that's different than for what Allison mentioned before. If the disability onset prior to the age of 18, and it's Texas law, it's in the Texas Family Code, that a judge can order child support for the child's life. And if the child receives child support, the Social Security Administration characterizes the child support as 100% the child's money. The child can be 40 years old, the disabled person's money, which will totally disqualify him from getting benefits or lower the amount of the benefits received. However, government has a little nice thing here. You can pay the child support can be payable to the trustee of a child support special needs trust. It has to be a first party trust because it's being funded with the child's own money. And then the child can get the full benefit and the child support. And it really can help. It really helps because it can provide a lot for the quality of the life and take a lot of stress off the custodial parent, especially for those kids that are require so much supervision. It's hard for the custodial parent to get out. So I hope I explained that well. But the first party trust is going to have the Medicaid payback provision. I had a case, well, I've had several cases where they had proceeds from lawsuit settlement, and the girl was born fine, and then there was bad car wreck when she was just a toddler. There was a large lawsuit settlement. It was managed by a bank trust department. She died prematurely. She was about 30, but and she had several million from the lawsuit settlement in the bank trust department. It was a Medicaid payback trust, and the parents said all along, I did the guardianship when she turned 18. They said, we're fine having to pay back Medicaid because we had capped out, this is pre-Obamacare when insurance policies could cap out on coverage. We capped out on our private insurance, and they had good insurance. The father worked for an oil company here in Houston, but it capped out. Medicaid pays for her multiple surgeries. And the trust could give all the quality of life things. The trust paid for her full-time nanny care, her care provider care. It paid for all the accommodations in the house. It paid for multiple other expenses that the parents would have had to pay for out of pocket. On her death, Medicaid was notified. They put a claim on the trust. There is still money left that went to the remainder beneficiaries, but you can use the money in trust. Some people think if it's in trust, you can't touch it. They could use the money to just make life a little easier for them and still have the benefits for her.
We have a few questions and a few things that I want to clarify because you said something that was so critically important, and we see people make this mistake all the time of specifically naming your disabled child, whether a child or an adult child with a disability, directly as the beneficiary. So rule number one, we don't name our disabled child or adult child as a beneficiary on anything we have, bank account, anything. And we have intentional conversations with our parents and grandparents and let them know that they shouldn't name that child directly. But what I want to be clear on, because I know you hear this all the time too, Michele, of, well, should I just disinherit the child? No, you should have a special needs trust and set up the trust to leave the life insurance proceeds to the trust as opposed to the child directly. So when you do it and you set it up correctly on the front end, you leave it to a third party special needs trust. There is no Medicaid payback, and you maintain the eligibility for state and federally funded programs. If you name the child directly, then then they are subject to lose their benefits, and then you're going to have to go get a court order, and the only thing that they're going to approve is a first party special needs trust that does have a Medicaid payback. So I want to make that clear. But I just want to talk about that whole idea of, well, I'll just disinherit this kid and I'm going to leave everything to their siblings. Their siblings love him and they're going to take care of him. I am not a fan of that idea, Michelle. I feel like people get married, people get divorced, people die, people get sick. Life happens to your other children. And if you disinherit the disabled child when life happens to the other child, it may mean that your disabled child doesn't end up with any money at all. It got tied up in a lawsuit, it got tied up in a divorce. Just there could be so many problems with that. So I want to warn against that. Talk to us about that. I know you have opinions on that.
Strong opinion. And it's totally aligned with yours. I say absolutely not. That's a burden on your other children. Your other children need to know, in my opinion, your other children need to know this is the pot for our sibling who has disabilities. You're going to be the remainder beneficiaries, but this is their pot. Because if you leave legally, if you leave money to your other child, I have people say it to me all the time also, Allison, if you leave your money to the sibling, the sibling owns the money. Well, he knows he'll take care of her sister. To what extent? Like Allison said, life happens. He may have his own needs. Or sometimes, let's say there's two siblings. Well, we're going to leave divided in half between the two siblings. They'll take care of their sister. I always say you're setting up for a rift with your children when you're dead. Because if one daughter has disabilities and there's two other sisters, and sister A takes Susie's got the disabilities. So sister A takes her out to eat, buys her new clothes, takes her to the doctor, and then sister A calls sister B and says, "Can you take over a little bit here? I'm doing everything. I can't do it. Or I just bought her all new clothes. It's time for you to pitch in." Well, I can't do it right now. We have extra expenses in our own house, just like Allison said. They're going to end up resenting each other or fighting. Leave a pot that your children know. There's something else, Allison, and you can address this better than I can. My disclaimer is I am not a CPA and I'm not a financial planner. That's what you want the consolidated planning for. But if you are heavy of a lot of what you're going to leave your children, and here in the Houston area, we really have this because we have the oil companies headquartered here. We have the huge Texas Medical Center headquartered here. And a lot of people that come in for planning have the bulk of their estate, other than the residents, the bulk of their estate will be in all sorts of retirement benefits. There are special tax laws for inherited IRAs. And you may know this, and I don't want to get into a whole discussion of taxes, but a spouse who inherits IRAs, that's one tax, that's one way of being taxed. I won't get into that. An inherited IRA, so if you leave IRAs for your children, your adult children, they have what's called the 10-year stretch. They have to pay the taxes within 10 years. You may recall, or maybe you haven't faced it yet, but retirement benefits are deferred taxes. The government allows you to grow money without paying taxes. But when you hit 73, you got to start paying those taxes. If you leave IRAs to a child who has no disabilities, now they're adults, they have 10 years, they have a 10-year window to get those taxes paid. It's called the 10-year stretch. It's under the Secure Act. Don't ask me what the acronym stands for. I can't remember. But there's an exception. If the IRAs are left, or a portion of the IRAs are left to a special needs trust, it's not subject to paying off the taxes within 10 years. The taxes have to be paid, can be paid over the lifetime of that child. So you may want that in your planning. And I've had people come in here and say that. I've had people, and I know you have this often, Allison. I've had people come in here and say, my 45-year-old son said, "Don't leave me IRAs. I'm already earning a lot. I'm an executive. I'm something high up in one of the oil companies or in one of the hospitals. I don't need to be adding on to my tax bracket. Leave that to my other child." So it's a good planning tool.
So we have several things that I want to address, but yes, for the lifetime stretch. So bottom line, don't name your child, your disabled child, a beneficiary. Rather name the third party special needs trust for benefit of said child. This includes 401ks, 403bs, life insurance, bank accounts, etc. What we most often see is that they name the spouse. If you're married, the spouse is the primary beneficiary, and then they may have contingent beneficiaries of the kids, and then the special needs trust for the disabled child. That's the appropriate way to go about doing that. I'm also not a huge fan of naming minors without disabilities as beneficiaries either, because the money sits in trust until they're 18, and then when they're 18 they get all the money. And I know your kids are brilliant just like mine, but no kid needs millions of dollars at age 18. It's a terrible idea. Okay, so one question that we had in the chat box is how much money could you have in a special needs trust? And the money is unlimited. There is an unlimited amount of money that you can have in a first party or a third party special needs trust. What they may be talking about, there are limits to ABLE accounts under the 529A for ABLE. And right now those limits are $19,000 a year for 2025. And I looked and it's the same for 2026.
Oh, okay.
And you can't have more than $100,000 in an ABLE account before you disqualify for SSI. So the person that's talking about limits, they're probably thinking about that. And that is true for an ABLE account, but you can definitely have an unlimited amount of money in a special needs trust. So let me look at some of these other questions. And also, change of beneficiaries are free, because I know people are cost conscious, right? Like if they're sitting here and they're thinking, gosh, I messed this up. And if you messed it up, I would say you're 95% of people where they name their spouse the beneficiary and then they say that they name their kids directly, equally. If I die and my spouse is dead and gone, that's easy. I'll just divide it equally amongst my kids. That's a very common thing that people do. It's easily fixed by getting a change of beneficiary form from your HR department, your 401k, old pensions, life insurance. They have free change of beneficiary forms. Now, if you do not have a special needs trust, a third party special needs trust set up, there are going to be costs associated with that, which leads it right into the next question, Michelle. Can you just, I know that you can speak for yourself and you can't speak for other attorneys, but could you give us an average ballpark cost of what people could expect to spend to set up a special needs trust? We've had that question come in about 3 times.
Yeah, I saw that question several times too on the for the pre-conference, and I want to come back, if you don't mind. I want to come back and say something. I'm here in the Houston area, Houston, all the surrounding the whole metropolitan area of Houston, so all the counties around us. But I'm also a member of, and I know I see Allison at the conferences, NAIL, National Academy of Elder Law Attorneys. I would think, I don't know, Allison, what you're saying. I would say probably be between 4,000 and 7,000, something like that. I've seen some attorneys charge more. I know people are cost conscious and they're worried, but one of the problems with go by the attorney's expertise. And then if you can get attorneys that are in this, similar level of expertise, then you could shop and see what the varying prices are. We see so many, I know, Allison, you see them, we always talk about it at these conferences.
Train wrecks.
Attorneys that are not familiar with special needs trust and the very specific language that the Social Security Administration requires, mix up the terms, and they take a trust that should have been a third party with no payback provision, ends up being a payback trust because one sentence or part of a sentence was included that shouldn't have been there, or there's some competing terms. And then the Social Security Administration will say, it's a payback trust. No, that's not what we intended. It's not a payback trust. Well, that's how it reads. And Medicaid can put a claim. I do want to just, these are the quick comments I want to add before you go on to the next question, if I may, Allison. Is that all right?
Sure.
Yeah, a couple things. One is we're talking about Medicaid payback trusts. Let's say on the young woman I talked to that died at 30, I had done the guardianship. She was in a car wreck when her mother was in a car wreck when she was 2 years old. The car seat collapsed on her. That's why there was a rather large settlement, because the manufacturer it was a big fight, but that's a whole nother story. On her death, there was about 4 to 5 million left in her trust. And once again, it was managed by a bank trust department under court supervision. It was a court supervised trust. Medicaid put a claim on it for 900,000 and they were reimbursed. And then the parents got what was remaining. That was a huge amount of money. But the point I want to make with that is Medicaid can't say there's 5 million left in the trust, we want it all. Medicaid puts a claim for reimbursement for what they've spent on her for medicals, not for the other benefits, at least till now, on her medical care. And that trust had enough to reimburse Medicaid. But if that trust had, let's say, 500,000 left, not 5 million, 500,000, and Medicaid said, you owe us 900,000, well, they can take what's left in the trust, but the Medicaid office cannot, the Medicaid agency cannot look elsewhere for repayment. They can only go to that trust. On a more, a better example for just a regular person without a huge, regular family without the huge lawsuit settlement. Let's say on your child's death, there is 50,000 left in the Medicaid payback trust, and Medicaid says we want 100,000. They could get the 50,000, but they can't go after you. They can't go after the third party trust. You can also negotiate with Medicaid for the payback. If the other way around, there's 100,000 left in the trust and Medicaid is asking for 50,000, so they get paid and then the remaining 50,000 goes to the family. So it's not that Medicaid can swoop in and take up all your properties. They have to make a claim, they have to substantiate it, and then they're reimbursed. The other thing I wanted to mention, I mentioned it, that there's three kinds of special needs trusts. One is a pooled trust. This is a good planning tool for many families that maybe don't have as much money or they don't have any family members that they can count on. They may not have enough to leave to use a bank trust department, because bank trust departments do have minimums. In Texas, we have the ARC of Texas. There are a couple of, not I want to say a couple, there are a few national companies that manage pool trust. And what they do is they pool money. Your child would have a sub account with them, but it's pooled, and it's pooled for investment purposes and it's pooled for management purposes. So in general, they have lower fees and they'll take the smaller amounts of money. They'll take $5,000 or 15,000. No bank trust department is going to take that. Even 50,000 is considered small for a trust. So that's another option.
Okay, a couple of things I just want to address in the chat box. Is
Yes.
there a catch-up amount for an able account for a disabled person over a certain age? The answer is no. So they're talking about like in an IRA, if you're over age 50, you can do an additional amount. And they may also be talking about how you can max fund a 529C. You could do your 5-year contributions for a 529 college, which is true for a 529C, but not for the 529A. So there is no catch-up amount for that. So how should we fund a special needs trust? So we see people funding special needs trust from current assets. We see grandparents leaving inheritance to the for the benefit of the special needs child through their trust. And then we also have a lot of people that use life insurance. Now, there are other options other than whole life. Whole life is going to be the very most expensive way to fund a special needs trust, and there are other options. And we work with folks on that. But it is important to fund that trust so the money is there in the future when you're gone. And somebody asked, could my other daughter be in charge of the trust? So yes, could your adult daughter be a successor trustee when you're gone, who will pay for care out of the trust for your other disabled child? And the answer is yes for that. And I would say being a trustee is not a small job. It just depends on how much money is in the trust. But you want to, if you're going to name, you should name a successor trustee. And if you're not going to name a bank or an institution, you're going to name an individual, you do want to make sure that they have the financial background and financial wherewithal to do the job, because it is not necessarily a small job. And then I just wanted to echo you, Michele. Whether you work with Michele or you work with our firm or whatever, your situation is specialized. You do want to work with a specialist. We see disasters all the time. We see disasters in the legal paperwork, but like she was mentioning, we see disasters in beneficiary designations where you're working with an advisor that doesn't have any background in special needs. And I'm not saying they're not smart. I'm just saying that they're not educated regarding people with disabilities and preserving eligibility for state and federally funded programs. That is why it's so critically important to work with specialists on that, to make sure that you have the money in the right buckets to preserve the eligibility for these programs and for the future, including those Medicaid waivers that we spoke about earlier. It's just so important. Let's see, can you put, one person asked a question of, Can you continue to fund, can you continue to fund or replenish a third party special needs trust once you're dead, slowly after you're dead? And you absolutely could. You might have a family trust where the money is in the family trust, right? Is that right, Michelle? And then the
Yes,
family trust could make distributions as you wanted in
right.
your documents to
Yes,
the special needs trust. So you could do that from the grave with your documents if they're drafted properly. Is that right?
absolutely. I'm working on one of those right now as we speak.
Okay, perfect. Let me see here if there was anything else. I think we're at a good, I just want to look at a few of our other write-in questions. I think we've been hitting a lot of them. Um, Tips for, finding the most affordable source. It does cost money, and I would have given the range of 3,500 to 7,000, with 5,000 being a pretty good range on the special needs trust. There are programs, for the indigent, for low income. And you can put that in your Google search, and I honestly don't care what state you're in. You can, say legal aid and put in your county, and it will come up with the legal aid, groups in your county, and you can check in with them to see if they have reduced or free, trust or guardianship and things like that. So, I mean, outside of the legal aid, I see Disability Rights Texas. But again, it's going to be for reduced income. There are a few counties, and none that I'm aware of, that gives a free special needs trust, but there are a few counties in Texas. Galveston County is one of them that has grants that will do guardianship for free, but you have to live in that county. So you'll want to check. Harris County isn't one of them. Fort Bend isn't one of them. Most of the big counties that you live in are not one of those counties. But I did want to mention that. Okay, let's see. Questions about trust for a parent's assets instead of will or guardianship when you can't afford attorney. I mean, if you can't afford an attorney to set up a special needs trust, I mean, you don't have your guardianship in place. I mean, I would just be careful of not to name your child directly as the beneficiary. I guess if you could help it, what is your suggestion in that example if a person does not have the money to get the trust at this time?
Well, you can look at, once again, in Texas, I would contact the Arc of Texas in their Austin office. They have the master pooled trust. You need very specific language in your will that says anything for the child with disabilities is payable to the trustee of the Arc of Texas Trust, but you need to get the language from them. I'm telling you though, do not do online wills. We have one in my office right now. The woman that died did a will, she's left a will. It is has so many things wrong with it that it's going to cost more now if she had, and she had assets. I don't, people don't want to spend money. She left assets. There's money because she died and we know what she left. We're getting to realize what she left. She had sufficient money to pay for an attorney. I don't know why she didn't. She got this will online. It has so many deficits that we have to jump through hoops to get this thing probated. But she did leave a will. We can't just say it's a bad will. We're not going to use it because she left it. It has to be submitted to the court. So,
It's not a DIY project. There's so many things
no,
that are a
nobody.
do-it-yourself project, but your legal documents and this kind of planning is definitely not. One person says, do you have to have a certain amount of money to open a special needs trust? I've seen them opened with $5.
Right.
And I'm honestly a fan of funding it later,
Oh,
funding it
we
with
agree.
assets after, after your death, funding it with life insurance. I want you to keep your assets nimble for the 25 to 35 years that you might spend in retirement. Now, listen, if grandma and grandpa want to leave $10 million, there's no problem with funding the trust. But if you're going to retire and need to, be in retirement 25 to 35 years, you don't want to have your assets locked up to where you can't use your assets for your own benefit and your own retirement. But so you don't, the point is you don't have to have millions of dollars to open up a special needs trust. Anybody can do that.
I totally agree. I'm so glad to
I'm
hear you
just
say that,
looking.
Allison. I'm so glad to hear you say that because I agree. I tell people all the time, keep the money for you. You don't know what your needs are going to be. And you have to realize that under Social Security regulations, Social Security law, once the money's in the trust, it can only be used for the person with disabilities. You can't say, oh, I need a new roof. I don't want to dip into my investments now. It's not a good time to cash something out. I'll borrow it from the trust and then reimburse it. No, no, and no.
Can't do
You're
that for
jeopardizing your
sure.
child's benefits.
One person says, should one be concerned if the disabled person only has HCS waiver for Medicaid and no longer getting SSI? I think what they're
Yes,
asking is when they switch over from SSI to childhood disability benefits, are they going to lose the HCS waiver? And that increase in income and moving over is exempt. And the answer is no. You are not going to lose that HCS waiver, and you're not going to lose the HCS waiver if you stopped getting SSI either. Now,
but
there is income limits, which is 300% of SSI. So, like, if the person lost SSI because they went to work, they could work and still get the HCS waiver, but they cannot earn more than 300% of SSI, which for 2025 is 2901 a month. So that's important to note, but I'm not talking about Social Security earnings.
but you always want to maintain eligibility for Medicaid. And if there's too many assets, you might lose the Medicaid.
Okay, I went crazy on the slides here. I am coming back to the Medicaid waiver programs. We got about 10 minutes, so we'll move along. We spent a lot of time on that, but it is complicated and confusing, and you guys ask great questions. So I think we really actually hit on the Medicaid waivers. Michelle, I have an entire webinar on Medicaid
Yes.
waivers. I want to say that all states have Medicaid waivers. They may be called something different, but they all have Medicaid waivers. They are all designed to waive off some of the cost of care for caring for an individual with a disability. Some states have no waiting list at all. Texas, unfortunately, has a very long waiting list, 17 to 20 years. So if you're not on the waiver interest list, there are multiple lists. You'll want to get on there, and we have an entire presentation on this. It shows you how to get on those lists, how to check the status of your list, and where your child is on the list. And one thing that came up yesterday in a meeting that I had, Michelle, is a parent that I was talking to thought that these waivers were stackable, that you could just keep getting another waiver and keep getting approved and you could just stack them. You get one or the other. You don't, they are not stackable. So when maybe you're getting class and then you come up on the HCS waiver and you want to know if you should switch or not, and the answer is it depends. And I would say don't take advice around the water cooler, because what might be right for your child might not be right for their child, and it depends. Like, one might pay for more therapy, whereas one pays for housing and the other one doesn't. So you just really got to look at that very, very closely. Do you have anything you want to add to that before we move on?
Just that usually you'll be assigned a Medicaid care manager, and you can discuss that with the person. Well, what exactly do I get and how do I choose?
And this is just an example of some of the waivers in Texas. Again, if you're listening in from out of state, all states have Medicaid waivers. So you'll want to research the Medicaid waivers in your state. What I have found is the states that don't have state tax, Texas, Florida, they have very long waiting lists. States that do have state tax, states that are cost exponentially more to live there, they may have much shorter waiting list or no waiting list at all. But these states with no state tax, the list is long. So this is going to be in the slides that we're going to send out to everybody. This is the phone number to get on the list. MDCP, class, deaf, blind, multiple disabilities, HCS, Texas Home Living, CFC, and then the Star Plus waiver. So there's all the phone numbers, and you do need to call all of them, because your local intellectual disability handles those three: the HCS, Texas Home Living, Community First Choice. Then the 800 number handles MDCP, class, and DBMD, and then there's a separate 800 number for the Star Plus. So don't make the mistake, which many people have, of just contacting your local intellectual disability authority and thinking that you're on all of the lists, because you're not. So this is going to be an important slide for everyone. So getting started, I think we've hit on this too, Michelle, getting started with a special needs planner or an attorney that is nuanced in special needs, knowing the difference of a special needs planner and a special needs attorney, what they do and what we do, and that we don't do the same thing. And I would say beware of the attorneys and financial advisors that double dip and do the same thing. You want somebody that's highly specialized in your legal documents and the special needs. You want somebody that's highly specialized in the finance department and the money when it comes to planning for special needs. So again, whether you work with us or somebody else, work with a specialist that's specifically nuanced. But getting started, you're going to want to gather all the planning documents. These are statements: stocks, bonds, mutual funds, what 401k, 403b pension, what life insurance, what benefits do you have in place to cover you, your spouse, your family, and your loved ones when you're gone. And I think getting started, you got to think about the vision of how you want things to look for yourselves as well as your special needs child. We never have to tell parents to think more about their kid because that's all they think about. But we do have to remind parents self-care and what they hope their semblance of retirement is going to look like, especially if you're going to have a child that's going to be with you. Like, you're going to be responsible for that individual for the rest of their life, right? So that's going to be really, really important. So I think, we've had entire webinars on guardianship versus power of attorney or alternatives to guardianship. And we'll probably do another webinar with Michelle and take a deeper dive into that.
I hope
We
so.
talked about the special needs trust, but guardianship, the process can start 6 months prior to them turning age 18. Guardianship may or may not be necessary. Guardianship takes rights away, and there are alternatives that might be appropriate, but there are also times when those alternatives are absolutely not appropriate because the person doesn't have capacity and they need a guardianship. So I think Texas has gone right and left with this instead of right down the middle. And the way I see it, Michelle, is it's what's in the best interest of that individual and not right or left. But okay, so I think we've kind of taken a deeper dive. I know we're running out of time for today. When we think about how am I going to fund a special needs trust, we're thinking about SSI, Social Security or Social Security Disability. We're thinking about life insurance and other assets. We're thinking about ABLE accounts. And one question I get all the time, Michelle, is why should I have an ABLE account and a special needs trust? And the answer is an ABLE account is after tax money, it grows tax free distributions, and it can pay for shelter without a 1/3 reduction to SSI. And while a special needs trust can pay for shelter, if the person is getting SSI, there would be a 1/3 reduction. So to me, the ABLE account and the special needs trust work beautifully together. Okay. If there's no money, if there are no assets, if the assets are less than $100,000, we have less than $19,000 a year to put into an ABLE account, then an ABLE account may be fine. But I want you to know you cannot make a beneficiary an ABLE account. You can make a beneficiary a special needs trust, but you cannot make an ABLE account a beneficiary. So that is why it might be very important to have that special needs trust, even if you have, you know, like I think you were talking about the group trust. I'm sorry, I forgot the name of that.
The pooled trust.
The pooled trust. So that may be, a consideration. So these are all things that we take a deeper dive into, and we help people figure out how much money do I need to fund that special needs trust. And we look at places and what the cost of care at those specific places are. What age do you anticipate that your child might be going to live in a residential, setting? And we're able to do those care cost estimates, and it can feel overwhelming. But a lot of times when people are thinking about retiring, or they end up working forever because they feel like they could never have enough money to retire and still fund the special needs trust. And I just want to encourage everybody, there are definitely ways to get there. So Michelle, this is Michelle's contact information here on the screen. Michelle, you have consultations. I think you have a charge for an initial consultation, correct?
I'll speak to somebody for up to 30 minutes, and then after that I do charge. I
Okay,
found that I was just giving away, people want a lot of legal advice and then I never hear from them again. So I can't do that. And especially to go along with the disclaimer in the beginning, I can give general information, but if you want specifics for you, then I charge a fee.
sure.
It establishes the relationship.
We had a couple more questions. Are there disadvantages to ABLE accounts? To me, the disadvantage, if there was a disadvantage, is that there's a Medicaid payback on it, just like a first party special needs trust. But other than that, I find it mostly not restrictive. If it can be construed as achieving a better life for an individual with a disability, you can pay for it out of an ABLE account. So I find the ABLE accounts very beneficial. So these are things to keep on your planning radar. We did talk about a lot of those today. And again, everybody's going to get a copy of today's slides and a link to the recording. So any of those critical websites or phone numbers that we talked about, they're all going to be in our slides here as well. You're also going to have a link here for our upcoming webinars, and you can kind of see what those topics are and register for the webinars that make sense for you and for your loved one. This QR code will take you to our calendar where you can schedule a free personalized consultation where we will learn a little bit more about the planning that you've done so far and how we might be able to help you going forward. I always say it's not about looking back. Don't beat yourself up about what you haven't done. Some people have done a ton of stuff and their advisor is not nuanced and special needs and they just want a second opinion. Some people just need to get started, and some people have gotten started but they need to pick up where they left off. And it is all okay. You guys are here today, but we're here to meet you where you are in your planning process and help you take the next step to where you need to be. Not everybody can do everything that they need to do all at once, and a lot of times it's steps, but we help you align those steps so that way you know what direction, what is the first step you need to take, and we're going to help you take those additional steps along the way as well. Michelle, as usual, you are awesome and you provided us a lot of wonderful information. So thank you for sharing that. Thank you everybody for your awesome questions today. And
Yeah.
just be on the lookout for your email. Maybe check your spam. If you don't have an email later from us with the slides and a link to the recording, check your spam as well. So thanks so much, everybody. And I hope everyone has a great afternoon. And we're going to look forward to partnering with Michelle again soon. Take care.
Thank you.
Thank you. Bye
Bye.
now.
Bye.